Mr. Thomas, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Right out the gate, the judge drops the DWI bomb 6 months or $2,000. But listen closely, that Miranda warning, it's not just routine, it's the first domino in the legal process. Silence is golden here, especially with felony charges looming.
Yes, Judge. On December 21st, 2024, at approximately 1:30 a.m., the officers were dispatched in reference to a one-vehicle collision. Upon arrival, the officer observed the defendant's motor vehicle with major rear-end damage and debris all over the vehicle from having collided into an apartment complex. Upon contact with the defendant, both officers and a witness observed the defendant with slurred speech, strong odor of an alcoholic beverage, and red, bloodshot eyes. The officer also observed the defendant to be disoriented and stumbling. While on scene, the defendant became physically combative, belligerent, and aggressive with the officers and attempted to kick the passenger's door and headbutt the officer. During the altercation, the defendant grabbed the officer's right forearm and scratched him.
Phew. This went from DUI to WWE real fast, but here's the legal kicker. Once physical force is used against an officer, we're not just talking about bad behavior, we're in felony assault territory. The question is, how will the court balance intoxication with intent?
Breaking skin and causing him to bleed and feel pain. The officers made contact with the defendant's front passenger, his wife, who advised they were coming from a party where the defendant drank, and as the defendant was reversing his vehicle, he crashed into 2 garages and then fled the scene to continue looking for parking. The officers did not request standard field sobriety tests since the defendant was being combative and for officer safety. A blood warrant was signed and executed.
You look to see if he has any prior DWIs, please. Mr. Thomas. And then license.
Eligible, Your Honor.
Okay. Mr. Thomas, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using illegal drugs or alcohol, I'll put you in jail. No more PR bonds for you. Do you understand?
Yes, sir.
If you don't have if you don't have liability insurance in your name, then you're also not allowed to drive, and that's a bond condition of yours as well.
That warning from the judge classic courtroom heat, it's more than legal language, it's a public safety red flag. He's laying out expectations, and any slip could land the defendant in jail without a second chance. The system isn't messing around.
Do you understand?
Yes, sir.
You have a lawyer. They will take care of you. It's your responsibility to stay in touch with them. If they tell me they can't get a hold of you, likewise, I will issue a warrant for your arrest. Don't become a danger to my son, to my city. Otherwise, I only have one place for you. Do you understand? All right. I'll have you sign a reset with Ramona. You'll get with Francis for your bond conditions, and then you guys are free to go.
Thank you very much, Your Honor.
Please.
Yes, sir.
Sir, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Please.
On May 14, 2024, the officer responded to a resident in Harris County, Texas, in reference to a terroristic threat. The officer made contact with the complainant, who stated the defendant, the wife's uncle, threatened to return to the residence with a shotgun to shoot him, and that he would shove the complainant's pistol up the complainant's ass, and that he would return with a cartel so they could take care of it. The complainant stated he believed the threats to be imminent, and he feared for his life.
How did you get appointed so early?
He made a request for appointing counsel when he was in jail in Montgomery County.
Oh, okay, so he was...
And y'all appointed me, and then he got transferred here and
Got it.
received his bond conditions and general order bond last week.
Okay, let's pause. The guy allegedly threatens to bring a shotgun and the cartel, and yet he walks out with standard bond terms wild right. But legally, even terrifying language doesn't outweigh the burden of proof. Let me know should threats like these trigger harsher conditions before trial.
Cause to go forward with the case. I'm putting 2 conditions on your bond now. Not to be in possession of any weapons and not to have contact with the complaining witness in this case.
Yes, sir.
How long did you spend in jail, sir?
I was there the 14th all the way up till the time they transferred me here, and I believe I was released on the 20th.
How pleasant was your stay in custody?
It was not pleasant at all, Your Honor.
Okay. Then all I'm asking you to do are 2 things, and as long as you can do that, you and I will be best friends. Otherwise, it's not going to go well. I don't want to have to put you in, so just That's all,
I
okay?
understand, Your Honor.
Got a great lawyer, Carl. He'll take care of you. Just make sure you stay in contact with him and all will go well.
Yes, sir.
If he tells me he can't get a hold of you because you're playing games, you're off the radar, I will issue a warrant for your arrest, okay? So just stay in contact, follow the conditions, and that's it,
Yes, sir.
okay? All right.
Thank you, Your Honor.
We need him to sign conditions here, and then after that, he's free to go,
Okay.
okay? All right.
Thank you.
He signed conditions already. I think they're pretty much the same as what you just said. And he also has a MOAB in addition to the bond conditions, which have no contact with the defendant, no weapons.
They were signed by the magistrate on the 20th, Judge.
I don't know how they put the MOAB on.
He's got a copy of the MOAB.
And it's not a family member. There's no allegation of a family member, so they can't put the MOAB on.
Yeah. It's the
You know?
bond condition covered anyway.
But just so you guys know, I mean, there's no allegation of a family member in the information
Okay.
or in the 2B.
I believe it's the,
It's
it's
the
the,
wife's uncle.
right, the
Yeah.
complainant's wife's uncle.
Yeah.
But we can look at the.
It says, it only says, did then and there unlawfully threaten to commit an offense involving violence as opposed to like family violence or upon a family member. And so that's why just no contact and you'll be fine. Okay.
Not a problem.
Nobody-
All right.
nobody calling for judgment.
I'm okay. I'm okay with it. Yeah, I see it. All
Thank you,
right.
Judge.
We got you.
All right.
Thanks.
Thank you.
Take care, sir.
You want to leave the warrant?
No, I mean, there's no,
You want to withdraw?
hey, what do you guys say? I mean, I don't know if we can technically have it, you know? Because normally you would have either terroristic threat of a family member or there has to be some allegation of,
And then file the MOAB.
I mean, that's a
Or we
different
can
thing.
just
If you do that,
Weapon, just do
then
the
we
bond
can, you know?
conditions. Yeah.
I guess you guys think about what.
Are you okay if we just maybe step out and call the complainant really quickly and see if we can get in touch with them? And then we
Yeah.
can kind of decide.
Yeah. And the young,
Yes, sir.
Miss Young, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On December 21st, 2024, the officers were dispatched to a disturbance call at 11:03 p.m. in regard to an intoxicated female who had become violent. Upon arrival, the officer made contact with the complainant, a supervisor for Acadian Ambulance, who stated that he observed the defendant throw a rock into the windshield of a Chevy pickup and then run off. The complainant advised that the defendant used to work for Acadian Ambulance and was no longer with the company. The complainant estimated the damages to be in the amount of $500. The officer observed the Chevy pickup truck with a broken windshield.
Got it. All right, Miss Young, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using alcohol, I'm going to put you in jail. No more PR bonds. Do you understand? I'm also ordering you not to have contact with the complaining witness in this case, not to be in possession of any weapons as well. So Francis, this one, I need you, since we're monitoring her for alcohol and drugs, please. Okay. What do you do for a living, ma'am?
I did work at Acadian Ambulance, like you
You're
said.
working now?
At an interview yesterday, they said I would be hired on. I guess it depends on also the background check.
My question is do you have income coming in?
I will be, hopefully.
Do you have the ability to hire a lawyer?
Yeah, I will.
Okay. If you have any issues, just come back and tell us. For now, we'll give you time.
Miss Young is out here smashing windshields with rocks, and the judge gives her the no, booze, no new charges speech. But let's be real, what do you think led her from EMT work to criminal mischief? Bad breakup job drama. Drop your theories below.
So I'll have you sign a reset with Ramona. You'll get with Francis for your bond conditions, and then after that, you'll be free to go. Don't use alcohol. Don't pick up a new case, because otherwise I'm going to end up putting you in. Do you understand? Okay, ma'am, please. Mr. Jefferson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 22nd, 2024, at approximately 3:30 a.m., the officers were dispatched to the 800 block of Louisiana Street in regard to a motor vehicle parked on the Metro light rail tracks. Upon arrival, the officer observed the defendant's vehicle on the tracks, with the defendant asleep behind the wheel of the vehicle.
On the tracks?
Yes, Judge.
Ugh.
The vehicle was turned on and in the park position. Upon contact with the defendant, the officer observed slurred speech, glossy eyes, and an odor of an alcoholic beverage. Standard field sobriety tests were administered, 0 out of 4 on the one-leg stand, 0 out of 8 on the walk and turn. The defendant did not finish the test, and HGN was 6 out of 6. The DIC was read, and the defendant consented to breath. The results were .091 and .09.
He's on bond for an aggravated robbery.
Yes, Judge, that is correct. Out of the 174th.
All right, can you tell me if he has any prior DWIs, please? And
There's no
if
prior
he has a license?
And his license is eligible.
Mr. Jefferson, I'm now placing a restriction on you. I'm giving you a curfew of 9 p.m. to 6 a.m. And I'm going to put an ankle monitor on you so I know where you are at all times. You're on bond for a very serious case. Now you've picked up a new case. It's very possible they revoke your bond on the felony case.
Now this is where it gets serious. The man's already out on bond for aggravated robbery, then he gets caught parked on train tracks while drunk.
Do you understand? I don't want you out in the middle of the night. If I find that you violate these conditions, I'm going to put you in custody. I'm going to protect my county at all cost. Do you understand? If I find that you're consuming alcohol or illegal drugs, likewise, your bond will be revoked. You will go into custody. And I'm telling you now, if I find that you're a public danger, I'm going to make it sky high. You missed court yesterday. So I don't want you to say anything. You have the right to remain silent. Exercise that right. The only thing I'm telling you now is I will give you a pass because you missed yesterday. If you ever miss court again, this is not going to happen. Do you understand? I'm going to reinstate the bond now. Francis, do you need the cause number for this case?
I have it.
You have it? Okay. No alcohol, no drugs, no weapons. And he now has a GPS monitor with a curfew of 9 p.m. to 6 a.m. You must charge this ankle monitor on a daily basis for at least an hour. If the battery goes dead, so does the bond. Do you understand?
Sure.
You can waive all the fees as well. All right. I'd like him to get it today as well. Francis, please. All right, Mr. Jefferson, what we're going to have you do is I'm going to have you go to Ramona, sign a reset, and then you're going to get with Francis for your bond conditions. You're already in enough hot water as it is. All you're doing is you're adding fuel to the fire, man. Really. Don't say anything. I'm just telling you how to behave in this life. There's certain ways to act, certain ways not to. Do you understand? Come on. You were charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one,